Assalamu alaikum. Today I am going to discuss a very important topic, public international law, that's state jurisdiction. Let's try to define at first the term state jurisdiction. State jurisdiction means the capacity, the legal power of a state to prescribe law, enforce the law, as well as adjudicate them. Okay, there is a strong link in public international law between state jurisdiction and sovereignty of state. Actually, the state jurisdiction is reflection of sovereignty of a state. Okay, there are some principles of state jurisdiction. Let's see the principles. There are following principles of state jurisdiction, such as territorial principle of state jurisdiction, nationality principle of state jurisdiction, protective principle of state jurisdiction, and universal principle of state jurisdiction. Okay, now let's describe this principle on by on. Okay, nationality principle of state jurisdiction. According to this principle, a country will have jurisdiction over its national, its citizen, wherever this citizen commit crime in the world. A state will have jurisdiction to try a accused or victim based on its nationality. Okay, an accused persons or victims state will try the case. We notice the application of this principle in following case, although there are many cases where the principle of nationality uh, jurisdiction is applied. I have only mentioned here three cases. First one cutting case, and secondly USA versus Yunus case, thirdly Lord Haha case. And this case I have already discussed these cases in details. If you want to see this case, this you may watch it from the link given in the description. Okay, and the nationality principle of state jurisdiction may be classified into two categories. First on active nationality and second on passive nationality. According to the active nationality principle, the state of the person who is accused in a crime will try the case, and according to the passive nationality principle, the victim's states will try the case. Okay, and now see universal principle of state jurisdiction. According to this principle, there are some crimes such as war crimes, crime against humanity, genocide, piracy, slavery, etc. These crimes are very serious crime. Whenever this crime will be committed in any country, anywhere in the world, any state in the world will have jurisdiction to try the criminal who commit this crime. Okay, universal jurisdiction. And we notice the application of this principle in the case of Attorney General of Government of Israel versus Eichmann case. This case also has been discussed previous video in details. If you want to see this video, this case. You may watch it from the link given in the description. Okay. Then the next principle is territorial principle of state jurisdiction. According to this principle, a state has power to exercise its jurisdiction over person, property, and event which are primarily within its territories. Okay, such a jurisdiction of a state will extend over its land, national airspace, internal water, territorial sea, national aircraft, national vessel with flag. Okay, we notice the application of this principle in Lotus case. And territorial jurisdiction also classified into two categories: subjective and objective territorial jurisdiction. Let's try to understand these two type of territorial jurisdiction in its by a simple example. Suppose the BSF of India fire from India a Bangladeshi citizen, and the Bangladeshi citizen is in the territory of Bangladesh, and BSF is in the territory of India. And according to the territorial principle, both the country, India and Bangladesh, will have jurisdiction to try this case. Here, the jurisdiction to try this case of India is subjective territorial jurisdiction, and the jurisdiction to try the case by Bangladesh is objective principle of territorial jurisdiction. And finally, the protective principle of state jurisdiction. According to this principle, whenever any crime is committed anywhere in the world, whenever any crime will be committed by a foreigner outside of the territory of a particular country, but such a crime will affect the security, the sovereignty of that country will have jurisdiction to try this crime to protect its security, protect its sovereignty. Okay, the best example of the application of this principle is Lord Haha case. This case also has been discussed in previous in detail. If you want to see this case, check the description box. But before doing so, you please subscribe my channel. Thank you.